Thank you for joining us here on this historic day. For those of us living in the 21st century, it's very difficult to imagine what it must have been like to live as a serf in Europe at the turn of the 13th century. Your rights, if you had any, were largely circumscribed by your feudal obligations. You owned nothing, not your land, not your chattels, not even your daughters. But in England, things were very different. The conquered Anglo-Saxon population, which for centuries had regarded their kings as leaders among equals, rather than an overlord, had become habituated to governance which was neither tyrannical nor arbitrary. The Norman barons who asserted their rights in the field of Runnymede in 1215, near Windsor, were not doing so because they were outraged by the king's arbitrary rule, but they were asserting rights that they knew they had and were natural to them, and they'd been asserting them for centuries before. In many ways, they had gone, as John Hancock, one of our speakers, has picturesquely put it, native. When you realise that the rights that the Norman barons were demanding of their king were not 100 years old, but 800 years old, that's in 1215, the enormity of the heritage which is our lot begins to dawn on you. We are the beneficiaries of an old and sacred tradition, passed down from generation to generation, and realised in a succession of documents that resulted in the Declaration of Independence and the US Constitution, and which preserve our fundamental natural rights. The colonists in the 1770s who rebelled against the British, claiming that they would not be taxed without representation, were doing so as British subjects, not Americans, and acted upon their long-cherished ideals as English freemen, and of course, with the Magna Carta backing up their claims. There is absolutely no doubt that without the Magna Carta, there would not have been a Declaration of Independence, no American Revolution, and no Constitution. In short, the world that we know today, with all its attendant rights and freedoms and human liberty, would not have come into being. Sadly, that is an idea that many present-day historians and academics are unwilling to recognise or give credence to. For them, the Magna Carta was nothing but a backroom deal between a crooked king and his cronies that the king almost immediately repudiated anyway. Well, he did repudiate it, but his successors did not. And the Magna Carta was reaffirmed and reissued in different forms over 40 times before being codified in English law before the end of the 15th century. We have convened this conference today in order to address both the deep historicity of this event and its impact on our present lives, examining the way in which it gave rise to due process, equality before the law, habeas corpus, the earliest forms of representative government, and the very concept of human liberty. And we're also here to examine the Anglosphere and how the ideas contained in the Magna Carta pollinated and then radiated across the world, carried to the New World by the Pilgrims and the colonists, brought to Australia by the convicts and their overseers, and spread throughout the countries of the world by merchant seamen who plied their trade over the Atlantic, Pacific, and Indian Oceans. This story of the spread of liberty is unlike any human story in our history. It is an extraordinary argosy worthy of Homer, and its impact has reshaped the world, allowing millions to aspire to prosperity, freedom, and happiness. So it is these things that we celebrate today, And while remembering the struggle has taken to reach this wonderful place in human history, we also remember the many lives that have been lost, the millions of lives that have been lost in that process. I thank you for recognising the importance of this date, and I hope you will enjoy the extraordinary range of speakers that we have gathered here for you. I want to ask you, please, to turn off your cell phones. I want to also ask you to please refrain from speaking during the course of the panels. I also want to refer you to your packets, your conference packets. You have in there a wonderful source book which has some extraordinary writings, has a bibliography. I really urge you to read it and take note of some of the commentary in there. It really is terrific. Some of our speakers have actually contributed to it, and I want to thank Mark Shaw for editing it and putting it together. And I also want to let you know we have books for sale of some of the speakers tonight. And we also have an event tomorrow night, on Monday night, that we encourage all of you to come to hear James Bennett speak on the Anglosphere Challenge and America 3.0, and how he believes that we are at the cusp of a reinvigoration of America and of the English-speaking world. So without further ado, I would like to now bring in some of our friends from overseas. I'm an Australian, as some of you know, and my former Prime Minister, John Howard, a good friend of the American Freedom Alliance, agreed to participate in this conference, and he couldn't be here in person, but he's got a few words to speak to us today.
Hello there. In the years that I was Prime Minister of Australia, I naturally reflected on many occasions about those things that drew Australia close to other countries. Often they were economic ties, often they were shared experiences in the past, often they represented combined effort to deal with the current challenge. But I emerged from that experience believing very strongly that the ties that bind nations closer together than any other ties are common values and common principles. And that really is the context of celebrating 800 years of the signing of the Magna Carta in 1215 between King John and the barons at Runnymede in England. Magna Carta is one of those fundamental documents to the sort of society that exists in the United States, in my country, Australia, and in other nations, particularly, of course, the United Kingdom. Magna Carta has never been the be-all and end-all of our freedoms, but it put down in black and white terms, for the first time in English history, a clear statement that arbitrary arrest and imprisonment and expropriation of property and unreasonable levels of taxation by a despotic monarch would not be accepted. And although many things have happened in the centuries that have gone by since, you only have to state those fundamentals in Magna Carta to understand how fundamental they are to the type of societies we now have in our nations. And any American audience will appreciate how directly those principles related to the principles of the American Revolution. And they will know that those who led the revolutionary movement in 1776 will also know that at the time they asserted the rights and fundamental freedoms of Englishmen. And those rights and fundamental freedoms derive very much from the Magna Carta. So when I look around the world and I think of the nations that we are very close to, I find that so many of them are nations whose experience and attitudes and values and principles have been shaped by such documents as Magna Carta. Things have been added over the years, and of course some nations such as the United States have gone down the path of having a Bill of Rights, which allows the courts to determine rather more things that are determined by Parliament in nations such as Australia. The fundamental rights of trial by jury, of freedom from arbitrary arrest, of habeas corpus, and those things that we take for granted but in a way never should, all have part of their history and their lineage in Magna Carta. So as we approach this 800th anniversary, we should pay tribute to the men of Runnymede, the barons of Runnymede, who put their hand up and said stop to an absolute monarch who was seeking to interfere with what they saw as the fundamental freedoms of Englishmen, and they, of course, not only remained and expanded as fundamental freedoms of Englishmen, but of people around the world, including, most importantly to me and to the audience I'm addressing today, Americans, because those ties of values and principles which bind us together are really more important than any other ties. Thank you.
Hi guys, I'm Daniel Hannan. I'm the Conservative MEP for the South East of England, and I'm sorry not to be with the American Freedom Alliance tonight, but as you see, I am at Runnymede, the place where freedom was born. It was on these green, soggy fields that King John stomped his irritable way to put his seal to Magna Carta. And I reckon that's got a pretty good claim to being the moment in human history when political freedom, constitutional government as we understand it today, took its birth. That was the moment when the law was raised above the government, when it was accepted that no one, not even the king, stood above the folk right of the people. The rules were placed above the rulers. Now, you guys, I think, were onto this before we were. Behind me you can see the first British monument to mark the site. We're more than half a century after the pillar that was raised here by the American Bar Association. And I suspect the reason that Magna Carta was always a big deal on your side of the Atlantic it's that when the first Americans arrived, they left Britain when the mania for Magna Carta was at its height, early part of the 17th century, and they carried that bias and disposition to their new homes, which is why to this day, if you go to the National Archives in Washington, D.C., you find Magna Carta next to the two documents it directly and immediately inspired, the Declaration of Independence and the US Constitution. What happened here at Runnymede was a little miracle. Beginning of the rule of law. Once you accept that the guys in charge can't just make things up as they go along, much follows. Free speech, free contract, free association, freedom of conscience, all the things we take for granted had their genesis here, and they were distilled into the noblest and purest form in the old courthouse in Philadelphia. This is our shared heritage, we who speak this language. It was our greatest gift to the rest of the human species, a system that for the first time anywhere elevated the individual above the collective. That is our joint patrimony, and that's why we remember, after all these years, the Charter signed at Runnymede.
I hope you like our little King John tent. You're all wondering why we're sitting under a tent, right? Well, now you know. We are back in the 12th century tonight. And we really are, in some ways, back in the 12th century. We are...
See, I assumed that if everybody else's was right, mine was right. I shouldn't have just made that assumption.
We are here to actually discuss the Magna Carta, and the Magna Carta is the translation of it is in the back of your source books. You can all take those out. I'm going to read from this source book and from this translation. It's from the British Library, of course, in Britain. The title of this panel is How the Magna Carta Gave Birth to Representative Government, a Parliamentary System, and the Liberty of the Individual. Well, it actually gave birth to much more than that. And part of it was, of course, equality before the law and due process. Clause number 2. To all free men of our kingdom we have also granted for us and for our heirs forever all the liberties written out below, to have and to keep for them and their heirs of us and our heirs. And then clause 21. For a trivial offence, a free man shall be fined only in proportion to the degree of his offence, and for a serious offence correspondingly, but not so heavily as to deprive him of his livelihood. In the same way, a merchant shall be spared his merchandise, and the villain the implements of his husbandry, if they fall upon the mercy of a royal court. None of these fines shall be imposed except by the assessment on oath of reputable men of the neighbourhood, which sounds very much like a grand jury. Clause 39. In future, no official shall place a man on trial upon his own unsupported statement without producing credible witnesses to the truth of it. And number 41, and probably the most powerful clause of all. To no one will we sell, to no one deny or delay right or justice, which would seem to apply to the entire populace and not just the barons who are presenting this particular petition to the king. So the question is, how did these elements give rise to the institutions that have arisen to safeguard our liberties and our freedoms? This is really the question of the Magna Carta, and so many people have been asking me in radio interviews I've done and in preparation for this conference, you know, why is it so important? Why does it matter? And one of the things that we're going to discuss in this panel is the genesis of the institutions that gave rise to the United States and to the United Kingdom, which are the leaders of the Anglosphere. So it's my pleasure to introduce our first speaker for today. Sitting to my left, Timothy Sandifer is a principal attorney at the Pacific Legal Foundation, the author of three books, including The Right to Earn a Living, Economic Freedom and the Law, The Conscience of the Constitution, and The Declaration of Independence and the Right to Liberty, which is the most recent book. Very happy to welcome Timothy Sandifer.
Thank you. Well, at the risk of being inhospitable, I'll start by saying that when I told my wife that I would be coming to commemorate the anniversary of Magna Carta, she said to me, well, take care that you do not over-commemorate it. And she's right, because it is very easy to exaggerate the importance and relevance of the Magna Carta as a document of freedom. The Magna Carta was the beginning, was the first step toward some very important achievements, including the Declaration of Independence or the Nuremberg tribunals. But it was really only an initial step, and we shouldn't lose sight of its shortcomings. Now, one of the great important achievements of the Magna Carta was actually a provision which you did not read, which is listed here as number 40, I believe it is. It varies in different editions of the Magna Carta, but number 40 says, no free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any way, nor will we proceed with force against him or send others to do so, except by the lawful judgment of his equals or by the law of the land. Law of the land, lex terrae in the Latin, which is where we get the phrase due process of law, and it continues to appear in our state and federal constitutions. And that was a very important step in the establishment of the rule of law ideal, because it means that not everything the king says is law, which, as Mr. Hannon said, that is a crucial step, because you find yourself in a position that Plato described in the dialogue the Euthyphro. If you remember the Euthyphro, Socrates asks, what is goodness? And he is told, goodness is that of which the gods approve. And he says, do the gods approve it because it is good, or is it good because the gods approve it? This is very important, because if it's good because the gods approve it, then anything can be good or bad simultaneously. It doesn't make any difference, right? Whatever the gods say just is automatically good, so there really is no such thing as goodness. On the other hand, if it's good and the gods approve it because it's good, then that means goodness is an objective quality. It's possible for something to be good even if the gods aren't aware of it, right? And we might be able to determine whether something is good even if the gods haven't spoken on the question, right? That's exactly the same position you find yourself in under the lex terrae clause. Something isn't automatically law because the king says it. Some things the king says are not law, and some things that he says are law. And that opens the door just a tiny bit for a group of people known as lawyers to argue about what things the king says are law and what things the king says are not law. And there you have the very beginnings of free government, right? And that was the legacy that Magna Carta taught to the American colonists. And it taught it to them through the greatest lawyer in all history, Sir Edward Coke. Sir Edward Coke was Queen Elizabeth's Attorney General. He was Chief Justice of England. And he wrote the textbooks called the Institutes of the Common Law that were the textbooks that the American founding fathers read when they were studying law. There's an amusing letter from a 16-year-old Thomas Jefferson complaining about how awfully boring it is to read Coke. So Coke is who taught the Magna Carta to the founding fathers. And Coke, when he was judge, used the Magna Carta to protect a long list of what we today call unenumerated rights, including the right to earn a living without unreasonable interference from the government. In a case called the case of the monopolies, the law made it illegal for anybody except a person who held the monopoly to make or sell playing cards in London. Now, why would you do that? Why would the government make it illegal to sell playing cards in London? To protect the public, right? No, of course not. It was to give a benefit to the person lucky enough to receive the monopoly, right? It was just private interest legislation just like we have today. And the court struck it down and ruled that it violated the lex terrae provision of the Magna Carta because every Englishman had the right to earn a living without unreasonable interference from the government. That was the beginning of a series of cases, many of them decided by Lord Coke, that upheld economic liberty as a fundamental right of all Englishmen under the Magna Carta. And the founders learned from this, and the colonists learned from this. The most important case, I think, from the early American law is a case called Bauman versus Middleton from South Carolina, where it was a land dispute. Two people owned land under conflicting deeds. In 1712, the colonial legislature had passed a law attempting to settle the dispute by saying this guy owned all the property. Well, 80 years later, the case comes to a dispute comes to court, and the question is, who owns the property? And the court struck down the 1712 law, saying it violated the lex terrae provision of Magna Carta to simply, by legislative decree, determine that this guy owned the property without any hearing or trial of any sort. And that was the beginning of a legal principle that we today call the no A to B principle. That is, government cannot take property from A and give it to B. That obviously is no longer the law today. You're all thinking about the Kelo versus New London eminent domain case almost exactly 10 years ago, in which the Supreme Court said it's perfectly okay to steal property from some people and give it to others in violation of 800 years of Anglo-American common law tradition. The most articulate explanation of the law of the land provision actually came in 1819 in Daniel Webster's argument in front of the Supreme Court in the Dartmouth College case, in which he said, the law of the land cannot just be whatever the legislature passes. Not everything the legislature passes can qualify as the law of the land. If that were the case, then the legislature could ignore the law of the land provision by simply passing a law that violates the Constitution and then saying, well, that's the law of the land because we passed it, right? That would be begging the question, so that can't be what it means. Instead, lawfulness includes certain substantive limits on what the government can do. That is to say, individual rights. So that was the important thing that the Magna Carta taught to the American colonists. On the other hand, there were shortcomings. For one thing, the Magna Carta does not speak of the rights of mankind. The Magna Carta did not, as Mr. Hannon said, elevate the individual over the collective. On the contrary, the Magna Carta was what James Madison called charters of liberty granted by power, which he said in Europe, charters of liberty have been granted by power, but America has set the example of charters of power granted by liberty. This revolution in the practice of the world may, with an honest praise, be called the most triumphant epic of its history, end quote. What Madison meant was Magna Carta, the English Bill of Rights, all of these charters that promised freedom to the people were just paper promises. They were pie crust promises, as Mary Poppins says, easily made, easily broken. And that's just what the British government had done, right? That's just what all monarchies had done. The most infamous such example was the Edict of Nantes in France, which had promised religious freedom to French Protestants, and then the king revoked it, which caused French Protestants to flee the country in fear of their lives, including among them was Apollo Rivoire, whose son Paul Revere became a famous American patriot. That's why Daniel Ramsay said in his 1789 History of the American Revolution, the colonists could not easily be persuaded that their civil rights flowed from the munificence of princes. Many of them had never heard of the Magna Carta, and those who had did not rest their claims to liberty and property on it. They looked up to heaven as the source of their rights and claimed not from the promises of kings, but from the parent of the universe. The American colonists believed that the 1766 Declaratory Act, in which Parliament proclaimed the power to legislate for the colonies in all cases whatsoever, had essentially revoked the Magna Carta. And why not? Parliament could always revoke the Magna Carta. Under the British Constitution, Parliament is, quote, omnipotent. In fact, William Black says it can do anything that is not naturally impossible. So, of course, Parliament could revoke the Magna Carta or any other provision of the Constitution. And that's why the Founding Fathers wrote instead the Declaration of Independence, which proclaims all men are created equal with inherent rights that no government may justly deprive us of. It's not a matter of humbly petitioning the king for freedoms. It's a matter of our having the rights and the government must humbly ask us. And that's why the Declaration speaks in such frank terms. It does not ask for anything. It proclaims. It's quote, candid. It, quote, submits facts to the world, right? And as Jefferson said, this freedom of language and sentiment becomes a free people claiming their rights as derived from the law of nature and not as a gift of their chief magistrate. To flatter kings in hopes of receiving freedom would ill beseem those who are asserting the rights of human nature. Kings are the servants and not the proprietors of the people. Or as an anonymous patriot wrote, Magna Carta was one of the happy dawnings of liberty, which must be considered as an imperfect emblem of the securities of the present grand period. What the American Founding Fathers did was take the next important step. And I would analogize it to the relationship between the New and Old Testaments in the Bible. This is probably an analogy that John Quincy Adams would have appreciated. John Quincy Adams said that, that for all of the glories of the great charter of Runnymede, it had not made the first step towards civilization and society for mankind. And John Quincy Adams would probably have appreciated the idea that where the Magna Carta was the old covenant for a chosen people, giving them freedom, the Declaration of Independence was a new covenant promising freedom to all mankind. Thank you.
It's really now my great pleasure. First of all, I want to thank you so much, Timothy. That was really terrific. It's really my great pleasure to introduce to you my colleague and my friend, John Hancock. We only really became friends about a year ago, or 9 months ago, when I was introduced to him. He called me up and he told me, I've written a book, do you want to read it? And I did, and it just it blew my mind. It's Liberty Inherited, and it's for sale tonight, and it's a fantastic book. I strongly recommend you read it. But let me give you a little introduction to John. And by the way, John is really the inspiration for this conference. He has... he and I wrote together a number of articles in anticipation of this conference. You can see on Breitbart and WorldNet Daily and on American Thinker. But John is generally recognised as one of the leading figures in the field of American exceptionalism, conservative history and foundational infrastructure of the English-speaking world. His signature work, as I've said, is Liberty Inherited, and explains the genesis of American liberty and freedom. He's also a co-host of a radio show called United IE, which airs on KTIE 580, and which is part of the Salem Radio Network. And it's my pleasure to introduce John Hancock.
Thank you. Thank you. You know, it is true that the Magna Carta was not the end-all, be-all. It wasn't even an introduction. It is true that some of the rights that were in there, that we ascribe to it to this day, it was never in there. Alexis de Tocqueville recognized that that the rights, or the rights that the Englishmen ascribe to the Magna Carta, are no more there than they are in the Bible. But what is important about the Magna Carta is what happened afterwards, what it created. And there's a story, a true story, during the English Civil War in the 1640s, 400 years after the Magna Carta. Now, you had the king, again, Charles I, trying to create absolutism in England. And you had the parliamentary forces rise up against him. And they had a military force called the New Model Army. And this was led by a gentleman by the name of Lord Fairfax. Now, the New Model Army defeated the Royalist forces, the Cavaliers, and entered London. But the problem is they haven't been paid by Parliament. They were hungry, and they had grievances. This scared Parliament because the Lord Fairfax had the power to take hold of the government and instill himself, or even Cromwell, as the head, basically as a dictator. Now, the Parliament, what they decided to do was to create a position and grant Fairfax to be the keeper of the Tower of London, where all the jewels were kept. And Fairfax went to the Tower and brought what he said was the most precious item, the most valuable item that they had in the Tower, the English people had. And he brought it down to his soldiers, and he showed it to them, and it was the Magna Carta. It was not the crown, it was not a scepter, it was not a jewel, it was the Magna Carta. And he said, this is what we fight for. This is why we march. And if we turn our backs on it now, then we are no better than Charles I or any other tyrant monarch. Now, this set a precedent that we see repeated again, very similarly by another man in another war by the name of George Washington. George Washington, at the end of the American Revolution, had the power. He had the army, and his army would follow him anywhere. There was a big move to make him a king or an emperor. And again, like Fairfax, he stepped out and said that, no, that's not what we're fighting for. We are not going to exchange one absolute monarch for another. We aren't going to exchange one tyrant for another. He was following in the footsteps of the Magna Carta and Fairfax because they understood the history. Fairfax and the English Civil War was only 100 years before, 130 years previously. That's like the American Civil War to us. They were very much aware of what was going on. So yes, it did not have everything, but as de Tocqueville realized, he said that it was not in there, none of these things, the parliamentary system and so forth, but it had the pole, it had the ideas embedded in it that only the English people in the 12th century could come up with, because already within their societies, liberty, the individual, was already embedded from the Anglo-Saxons. No other society in Europe could have produced a document that was produced by the English in the 12th century. And this was what de Tocqueville called the magic of the Magna Carta. I would call it the miracle of the Magna Carta, because it was so unique, and it ended up becoming a self-fulfilling prophecy. A lot of people don't realize that we all hear about how de Tocqueville came to America and did this great tour and wrote his 2 volumes of Democracy in America. But what many Americans don't know, that he also afterwards went and did a tour of England. And he wrote a book, Journeys of England and Ireland. because he realized something. He realized that the democracy in America, and it would eventually become Canada, and the rest of the Anglosphere, originated in England, which he called the point of departure. And one of the documents at the heart of that point of departure was the Magna Carta. And it goes back way past beyond that point. There was a John Motley, a famous historian in the 1800s, tells a story of a battle being waged between the Saxons and the Romans in the 300s. As they were fighting, it was a close thing, but the Romans won, but it was bloody. And the general walked out and looked at the carnage, the Roman general, and he saw dead and dying Saxon warriors laying next with dead and dying Roman soldiers. And when he looked around, he is reportedly said, these Saxons fight as if living with liberty is a curse. This is what was embedded in the English people. This is why they produced the Magna Carta. And this is why it was just a long line, and that we will talk to in later panels. But it was a line, it was opening the door. As they mentioned, there weren't many freemen in England at the time of the Magna Carta. But what happened was, as more and more people became free, guess what? They fell under the umbrella of the Magna Carta. The Magna Carta now protected them. And this is something that is being preserved and we are celebrating today. And I will finish with one quote that I think is very important by Edmund Burke. Edmund Burke said that liberty is a contract between the dead, the living, and those yet to be born. What we are celebrating is that contract that was kept for us, going back 800 years and even further. And us as a group, as people, it is our duty to preserve it for those yet to be born. Thank you.
Thank you, John. It was outstanding. Our next speaker, our last speaker, and then we're going to open up for questions. It's Byron Steyer. He's Associate Dean Designate of the Research and Professor of Law at Southwestern Law School in Los Angeles. He's a founding editor of the Mass Tort Litigation blog. He has quoted widely in the media and was honored with the 2009 Irving D. and Florence Rosenberg Professorship at Southwestern. It's a pleasure to have you with us.
Thanks so much. Thanks. Wow, my goodness. Is this working? And thanks so much for everyone coming. What a wonderful thing to be honoring here today. Thank you, Avi. So in December 2012, I was in Washington at the National Archives, and I had the opportunity to take a stroll. I hope you all have an opportunity to take some time in your lifetime to look at these documents in the original form, one by one, in the space of about maybe 50 feet in one room. It's one of the most remarkable things you can do if you really care about the foundations of freedom, not only in America, but in the broader Anglosphere, in the world generally. And during the time I was there, it was one of 3 days that the Emancipation Proclamation, which is written in Lincoln's own hand on several sheets of paper, was up for display. It's very rarely displayed because it's so fragile. So in the space of about 50 feet, I had an opportunity to read all these documents. And what struck me, including one of the original copies of the Magna Carta, which was there, what struck me like a lightning bolt looking at those documents was, my goodness, it goes that far back. It goes back to the Magna Carta. It goes through the Constitution. You can see it in the Emancipation Proclamation. It goes back through the Declaration of Independence. It goes back to 1215. And I would return to the paragraph that Timothy had highlighted earlier. When we think about due process of law and the Fifth Amendment and the 14th Amendment, the Fifth Amendment and the Bill of Rights, when we think about life, liberty, and the pursuit of happiness and the Declaration of Independence, let's also think about this paragraph today, especially in the Magna Carta, 1215. listen to the language and hear what will echo to us as life, liberty, property, pursuit of happiness. No free man shall be seized, this is paragraph 40 in your source book on page 142. No free man shall be seized or imprisoned, liberty, or stripped of his rights or possessions, liberty and property. I'm paraphrasing for us here. Or outlawed or exiled, again, liberty, or deprived of his standing in any way, nor will we proceed with force against him or send others to do so, except the government has some power. What power does it have? Except by the lawful judgment of his equals or by the law of the land. You have in this paragraph, perhaps for the first time in history, a strong statement agreed to by the sovereign that the sovereign cannot just do whatever it wants. They cannot, as was said earlier in the video, I don't know if it was from Daniel Hannan, who was great, as usual. You cannot just make it up as you go along. You cannot do anything. This is foundational to the rule of law as we know it today. It is the core of the rule of law. It's not surprising that it's the American Bar Association in 1957 that goes to erect the first monument to Magna Carta. It is essential as an inspiration for the American project. And let's go back to this, except by the lawful judgment of equals. Now, these were barons in 1215, and it was not extended to all free men. That was for the American project to complete that mission. But except by the lawful judgment of his equals, that will come to be the jury system as we know it in America and is embodied in the Bill of Rights, your right to a jury trial, or by the law of the land. We know that, again, as the rule of law. But I wanted to expand a little more broadly to comment about what that law of the land also means in the context of the British Empire and the British system, the Anglospheres we're discussing more broadly in this conference. The common law system, which Britain propagated throughout the world, is an essential system of decentralized authority, of judges and of individuals who bring their claims to seek justice before a court, of authority that is dispersed rather than centralized. The common law system is best set off against the civil law system. The civil law system is spread throughout continental Europe, South America, Asia, Germany. It draws its origins from Napoleon and through Napoleon back to Roman law. The system centralizes authority. The system writes the rules in one central location and then has judges apply without any independence, without any force of precedent for their interpretations, always deferring to the central authority who's written that law. That is a centralized approach. That is not the system that is the British system. That is not the system which was bequeathed and was accepted by the United States upon our revolution. It was decided that the common law of Britain was the common law of the United States. That common law system allows dispersed judges to make decisions about the individuals in front of them, to hear evidence, and to make dispersed authority decisions. We think, some in the room perhaps think of Hayek and the lack of centralized, the concerns about centralized authority not having all the information to make all the rules. The common law system could be seen as a more Hayekian approach, which is a perfect fit for where America goes with this. But we go further than that British project, which was already so good, right? It's remarkable that Daniel Hannan, a British politician, lauds the Declaration of Independence in Philadelphia as a remarkable moment in history. I agree with him, and we share that. But that's how great it is that even a British politician will laud the independence of America and Philadelphia from Britain. Where did we go with it? We embodied the jury trial among our Bill of Rights. People don't realize in America, I have co-directed our summer program at Southwestern Law School. We have a summer program up at University of British Columbia in Vancouver. People don't realize that the jury system is uniquely American in civil suits. In many parts of the world, you do not get the right to a jury trial. Here, it's not only important, it's in the Bill of Rights. It's distinctly American. We've also taken in America this adversary system where individuals who seek justice, they control their lawsuits. They have a say in the process. They're not just along for the ride, the way they might be perhaps argued to be in a civil law system. And just to close in terms of the current, most recent echoes of this, when you go back and you think, well, 1215, and we have we're in our King John banner here. It's hard to imagine that, oh, how important is this today? Is this relevant today? Well, for several years, number of years before going into teaching, I was a litigator in New York and represented a lot of corporations. And hopefully in this crowd, there's nothing wrong with that. One of the applause even, great. So one of the things that corporations find are very emotional pleas to take their money by people who don't have evidence and propose very undetailed procedures. One of my clients was a tobacco company, and we went around the country defending class actions brought against the tobacco industry. We were frequently faced with proposals for trial plans on behalf of millions of people. And in that trial plan was never any opportunity for those people to speak to a jury. The plaintiffs thought that wasn't necessary. We don't need to actually hear their evidence. We don't need to hear whether they're entitled to recover or not. We just tell a story and put a couple of experts on the stand to tell a story, and then we sit down. Or, as happened in one case I'm going to mention here in a moment, in the asbestos litigation, there was a proposal, there were thousands of plaintiffs, and the plaintiffs proposed in a class action, well, we'll just take like 20 or 30 and put them on the stand, and then the jury can kind of draw their conclusions for the other few thousand. And by the way, the 20 or 30 were going to be handpicked by plaintiffs' counsel. Some of them were allowed to be handpicked by defense counsel, but there was not going to be any kind of representative approach of that, and even a representative approach wasn't going to be very individualized. Well, in those moments, today across the country in courts, when counsel are faced with arguments that fly against individualized evidence, individualized proof, requirements of accuracy, sometimes judges will go along. It sounds efficient. Well, we'll just do it in a couple of days. We don't need to hear any evidence. And what is your last hope in that situation if you're a lawyer? It is due process. It is due process that you go to above all. You reach for the final nuclear button, as it is, of due process. Your Honor, what you're proposing, what's being proposed here, is indeed a violation of due process, something that goes all the way back to the Magna Carta. If I could share with you a little bit of language from the Fifth Circuit in an asbestos case and the fiberboard case, when they were faced with that trial plan without allowing individuals to testify or individual evidence to be judged. This is what the Fifth Circuit said in language that really is the heir to Magna Carta and due process. They said, "We are also uncomfortable with the suggestion that a move from the one-on-one traditional modes is little more than a move to modernity. Such traditional ways of proceeding reflect far more than habit. They reflect the very culture of the jury trial and the case and controversy requirement of Article 3 in the US Constitution." The court went on to say, "Ultimately, these concerns find expression in defendants' right to due process," which goes all the way back to Magna Carta. And further, the Fifth Circuit said, "We are persuaded on reflection that the procedures here called for comprise something other than a trial within our authority. It is called a trial, but it is not." And it was rejected. And it was rejected on the authority of due process that traced back through the Constitution, back through the Declaration of Independence, back to 1215 and the Magna Carta. Thank you.
An outstanding group of speakers, and I'm sure you'll all agree. I want to start by asking a few questions of my own, and then I'm going to open it to you. And in particular, I want to just go back to something I said in my own introductory comments, and that is that the liberties that we cherish today didn't gain their genesis really in the Magna Carta. It goes way back into Anglo-Saxon history and to the Anglo-Saxon kings, and back to Germany. Really, the German. I'm not saying the modern Germany or the modern Germans, but and I'd like John Hancock maybe to talk a little bit about that, about the history, the genesis of this idea of liberty and how it developed and got to the point. You know, you have said that the Norman nobles, barons, went native when they adopted this idea of liberty. Maybe you can give us some better understanding of that.
Sure. You know, one of the we use the term Saxon, but the Saxon people they were not a race at the time of Rome. What was interesting when I did research on this was to find out that the sax was a short sword that they carried, and they would be able to use that to get under the Roman shields and stab them. And so anybody who resisted the rule of Rome carried one of these swords, these little stubby swords. And the people who, so in time that became a symbol against Roman tyranny, against the Rome itself. And so anybody who started to carry one of these, the Romans started to call them Sajones, which meant in Latin, which would become the Saxon. So the Saxons were not just one people. Unfortunately, in America, the term Anglo-Saxon has been demonized so much with racial connotations, but they were not. But they were the difference between them and Rome is they were individual-centric society. The individual was the prime unit, and he was the person that the society operated for, each individual. Whereas the Roman system was the state. The state was the center of everything. And as we mentioned with Roman law, it was from the top down. The Caesars and the governors, they determined the law, and they wrote it downward for the people. But the Saxon system was very similar to what would become common law. It came up from the bottom. And what was interesting is the kings themselves were elected. They were not hereditary. In fact, they had the word king. He was more of a chieftain. But what is interesting is the word prince did not come into the English language until the Norman conquest in 1066. They did not have where all of a sudden the heir automatically took the throne. He could, but it wasn't required. They had a vote. They had something called a written, which would be the leaders would get together, and and this is proto-parliamentary. This is the first basic forms of parliament. And they would get together when a king died, and they would vote in a new king. What was also interesting about the Saxons is that women could not vote, but women had a say in their written. They could walk in there and they could make themselves heard, which was believable at the time. It was impossible in what would become France or what would become Spain, because a woman's place, like the old saying, the children's place is to be seen and not heard. Well, in those societies, that's how women were. But in Saxon societies, they could actually speak. So we have this long tradition going back to the resistance against Rome, going back to the 300s, which is basically, you're looking at almost 1,000 years before the Magna Carta. And this was brought over to England. It was in the Netherlands, and then it was brought over to England after the fall of Rome, and then it was basic there. Now, compared to modern times, sure, they were in a free society. There was a lot of inequality within the society. But that's not fair to judge people by modern standards. How would you like to be judged from people 300 years from now, 1,000 years from now? We're going to look like flat earthers too, to them, because their knowledge is so much further than what we have. Their understanding of things will be so much further. At least we hope so. So to be judged that way, no. But in their time, they were very exceptional. And this was brought, and what happened was when the Norman conquest came, the Norman brought that Roman rule into England. And for nearly 150 years, England suffered under authoritarianism. There were 7 kings. The king took all the land away. In fact, from the Saxons, he distributed it to his barons, to his helpers, his Norman helpers, and they ended up becoming the rulers of the land. The story of Robin Hood is the story of the Normans taxing the Saxons into starvation, and then taking that money and filling up their coffers with it. And Robin Hood was not stealing from the rich to give to the poor. He was stealing from the Normans to give the money back to the Saxons. But it's been completely distorted now. So what ended up happening, though, was one thing. Yes, the Normans, one of the big critiques is, oh, the Magna Carta was just an agreement between the Normans. Because, look, all the signers, all the barons had Norman last names. But as David Starkey, who is a British historian, he notes that in the 150 years between 1066, the Battle of Hastings and the Norman Conquest, and 1215, with the Magna Carta, you had intermarriage going on. The Normans would marry Saxon women. The Normans would marry off their daughters to Saxon men. So several generations later, even if they had the last name of a Norman, they had, as David Starkey, that was his quote, they had gone native. And culturally, they had become Saxons. So, in some ways convenient, because being Saxons, they could flaunt the power of the king. But they did become Saxons, and they were very much aware of what Daniel Hannan called the folk right that the Saxons traditionally enjoyed. And this was the Magna Carta among many of the Saxons was seen as a re-exertion, a reinstatement of those traditional folk rights that they enjoyed prior to the conquest. And we see this going on, and we see, again, this is what I said in my opening statement. The people who produced the Magna Carta already had individual freedom. They already had that tradition. It was already in their culture. It was already one of their values. And that's why I said another culture who would develop into the French or the Spanish could not produce this document. They didn't have it in them. But the English did, and that evolved from just being a basic document that did a little. But in its time, again, compared to today, what is that? I mean, it's hardly anything. What are these rights? These rights hardly did anything. But compared to their neighbors, to their contemporaries, it was a huge step in the right direction. You know, there's one part in there that back under Norman times, if a woman's husband died, she had to remarry or lose everything she had, her inheritance. If she remarried, it automatically went to the new husband. Magna Carta ended that. It said a widow does not have to remarry. A widow can keep her inheritance. Like I said, today that's not a big deal. In the 12th century, that was a big deal. And it was this that's why in my book, it's this liberty inherited that evolved going back to the resistance of Roman tyranny all the way through the English Constitution. And remember, we need to look at something. The Magna Carta, the Great Charter, is just one of many. The English Constitution is actually was a living document. It is a living document, but it was evolved over time. And there was many charters. And that's why some of the clauses got erased and removed. But there's something to learn about that. Something to think about. Why is it when you have a living document, the English Constitution, a living document that can evolve over time, based on what Parliament and what judges and people say it to be. Makes you think, why is it that our founding fathers wrote ours down? Because they understood that you can't have a living document as a constitution that could just be changed by the politicians and the judges of the land. Thank you.
When we had Daniel Hannan speak a few minutes ago, I didn't have the chance to really introduce him. And really, this is somebody everybody should know. He's an extraordinary intellect, and he's a powerful leader in England now. He stands for England and English values, and he's written a couple of fantastic books that I have to refer you to. One is called The New Road to Serfdom, which is a warning to America not to follow Europe's path. And the other book, which is probably one of the best books I've ever written, one of the most hopeful books and one of the most interesting books, is called Inventing Freedom. And that really inspired both John and myself in terms of this conference, in terms of giving us a sense of what really has happened over the last 800 years. And with that in mind, I'd like to ask both Timothy and Byron, it's fascinating to me that an Englishman like Daniel Hannan looks at the American Declaration of Independence and the US Constitution with absolute awe and reverence. What inspires him to feel this way about us and about our example? And what have we done to really merit that kind of awe and reverence?
Well, I'm probably the wrong person to ask, because I've argued with Mr. Hannan over this subject, because I don't think he actually does hold the Declaration of Independence in that sort of reverence. I think what Mr. Hannan represents is, although I admire him as a very eloquent spokesman for liberty, he nevertheless represents a sort of conservative strain in historiography that tries to portray the Declaration of Independence and the American Revolution as being within the boundaries of British tradition. He frequently likes to say that the English patriots, or the American patriots, were fighting for their rights as Englishmen, even though the Declaration of Independence proclaims that they are no longer Englishmen. Right? The great revolutionary achievement of the American experiment is the Declaration of Independence and its break with European tradition, and its proclamation not of folk right, but that all men are created equal, which, as Lincoln said, is a doctrine applicable to all men and at all times. And he said, all honor to Jefferson, who in the midst of a merely revolutionary document had the strength to insert a timeless truth applicable to all men and all times. I love the word merely in that quote. Lincoln says, in a merely revolutionary document, Jefferson had the foresight to insert a timeless truth that all men are created equal, and that these rights are the birthright of all human beings, regardless of their past. When I think conservative historiographers, particularly of the Russell Kirk school, try to play down the importance of the Declaration and of Jefferson, and to try and portray the American Revolution as being an attempt to reclaim the traditional rights of Englishmen, there's just enough truth to that to be misleading. And that is that there is a British tradition of these liberties that the Americans learned in the 17th and 18th centuries, but they also learned of how fragile they were and how imperfect the British constitutional protections for them were. Remember that in the 1600s, between 1600 and 1640 something, I think, the charters of Rhode Island, New Hampshire, Massachusetts, and several other colonies were revoked by the King of England. He revoked the charters of their colonies in order to create the Dominion of New England to be ruled over by a single person answerable only to the king. This was the kind of thing that the Stuart monarchy did. And then after the Stuarts, the depredations of George III, you read the Declaration of Independence, you really get a sense of the abuses that the American colonists suffered at the hands of the British Crown. These were not minor things. Well, I think it's really tragic that every July 4th, somebody says somewhere, well, you know, those colonists, they were just fighting over taxes on tea, which, you know, it was such a minor tax compared to what we pay today, which is true. But so they were just, they were a little bit kooky. They're right-wing extremists, right? When you read the Declaration of Independence, he has burned our towns. He has destroyed the lives of our people, right? He has, the Parliament has proclaimed its right to legislate for us in all cases whatsoever. But it's not just that they've violated the British traditions of liberty. It's that they have violated the fundamental principle of all civil society, which is all men are created equal with certain inalienable rights, and that no government may deprive us of those rights. So what the American Revolutionary tradition does is subsume the British Magna Carta tradition and transform it into something much more precious, much more beautiful, much more deserving of our praise. So I appreciate Mr. Hannon's praise of the American Revolution, but keep in mind that his portrayal of it in his writings, particularly in an article he wrote last year in National Review, which was just awful, trying to say the American Revolution, he actually claimed in that article that the American revolutionaries fought under the British flag, which is true, of course, until they created their own flag, right? They didn't have a flag for a little while. Washington raised the British flag at his fortifications overlooking New York, and it was mistaken for a flag of surrender. And so he asked the Continental Congress to create a new flag. Does that sound like he's fighting for the traditional rights of Englishmen? Of course not, right? The Declaration is not about the traditional rights of Englishmen. America is not about the traditional rights of Englishmen. It's about the rights of all people at all times, and that no just government may take them away. Insofar as what Mr. Hannon says is in defense of those liberties, and it very often is. He's an eloquent and powerful spokesman for these rights, and I admire tremendously the work that he has done in that direction, then I applaud him. But we have to keep in mind that there is a difference between the American tradition and the British tradition, and liberty for all is that difference.
Can I just come out of
Yes, absolutely.
So I mean, we should let Daniel Hannon speak for himself as we're all imagining what his responses are. Maybe he will tomorrow from Runnymede. I don't know if we can ask him. Yeah. So of course the American Revolution was a revolution against Britain, and we broke away. Of course that. I think though, and I'm not an expert on Hannon's writings, but so let's just go to the broader point. The countries that emerged from the British Empire, the British project, which also had the common law, and we think of the common law, it's Canada, United States, Bermuda, United Kingdom, Ireland, Australia, New Zealand, also through the colonies in India. Israel also adopted common law, and parts of Africa. But when we think about those countries, Canada, Australia, New Zealand, United States, these countries that emerged from Britain as well as Britain, these are the countries that are the chief expositors in the world of the tradition of individual freedom, and of limited government. That is the larger project that I think we can say, it's fair to say we've been a leading force in that regard, and we've gone further in our documents, but I'm delighted that someone from Britain considers us part of that larger project that they can claim as well. And certainly throughout history, we're going far afield with all of our analogies, but in World War II, the alliance between the United States and Britain, and with Winston Churchill fighting fascism and totalitarianism, was essential for preserving that project of limited government and individual freedom. And I would argue, warrants all within the larger project to take pride in the accomplishments of each of those countries.
I think it's fair to say they saved our asses in World War II.
Yeah. Okay, so now we've got some questions from the floor. It's a little hard. I'm wondering if, Marty, you could take the microphone so that people can, the handheld. Okay, so we have a question, Keith, down here.
Yes, I guess this is a question for any of the panelists, but because I teach and I work with a lot of kids. I work with youth, particularly high schoolers, and I know they would ask me this question, so I want to ask you the question as if a high schooler would be asking me the question. if I were to talk about the Magna Carta in its context. Number two, because I notice here a couple of phrases, but tell me if I'm reading, because I'm not a lawyer, but tell me if I'm reading something into it that it's not. Especially, I love the way Timothy is able to articulate and just spew this out so easily. I don't know. I notice you don't have a prompter or anything, but you know you're really good at this. So, in particular, I would ask you this. Let's see, number two here. Oh yes, the word starts out number two in the Magna Carta: to all free men of our kingdom. Just that phrase there, to all free men, does that somehow imply or indicate that there were some men who were not free? For example, you know, slavery was obviously practiced at the time. So could that mean that to all free men, did this not apply? Because we know obviously later on slavery was dealt with. But I need to know this because this is very important because of the way the kids would ask me. So to all free men of our kingdom, we have also granted. You know, see, they keep saying we granted, not the Creator, which is what I love the way Timothy brought it out. The difference in the Declaration of Independence, and I point that out many times with him, is that the Creator is the one who granted us rights inalienably. So once we abolish the idea that rights no longer come from the Creator, we now have rights that are alienable, which means here comes the tyrant. So anyway, back to my question is, that's what I'm asking is, in this Magna Carta, in this particular text, did they exclude the slaves? That's what I'm trying to say, I guess.
So in the 13th century, the term freeman originally referred to a particular class and did not include the serfs and peasants and so forth. They didn't care about the serfs and peasants and whatnot. What happened, though, was that Magna Carta really, as Mr. Hannon correctly said, the heyday of Magna Carta was in the 17th century. It was in Shakespeare's day, under Lord Coke, that Magna Carta attained its real importance in the Anglo-American common law. And this is sometimes referred to as the myth of Magna Carta. And that's a little unfair, because it's not a myth in the sense of being untrue. It's a myth in the sense that of a legend, right? This is what accumulated to Magna Carta was this principle of law of the land, that the king was subject to the law. There's a famous incident in 1609, I think it was. King James and Lord Coke, Lord Coke by that time was Chief Justice of England. They're sitting around the conference table, and King James says, "The king protects the common law." And Coke said, "No, the common law protects the king." And James, apparently, according to an eyewitness, flew into a rage such as he had never experienced before and shouted, "A traitorous speech! For if the judges may make of the laws what they please, they will soon make of them shipmen's hose." Shipmen's hose are the stockings that sailors would wear. He meant if judges can interpret the law will develop runs in them like old stockings. And of course, Coke, being a loyal subject, apologized immediately to the king, although he was very soon after fired as Chief Justice of England, which is why in the American Constitution you can't fire judges. That confrontation is sculpted on the bronze doors of the front of the US Supreme Court building in DC right now. So that was what happened in the 17th century, was that the principle that was originally extended only to freemen was gradually broadened to apply to all Englishmen under the watchful eyes of people like Lord Coke, who was one of the earliest of what we call Whigs, who later led to the English Civil Wars of the 17th century. And it's in the English Civil Wars that you see the founding fathers of our founding fathers. There's a wonderful new book out by Peter Ackroyd called Rebellion. I recommend it to all of you. It's about the Stuart monarchy. And I think all law students should be required to read this, because every page, you read it and you're like, that's why the Constitution doesn't allow that sort of thing. That's why that isn't allowed under the Constitution, because the Founding Fathers knew this history so well. Slavery was not really a part of the equation, because African slavery was not really introduced under the British Empire until the 17th century. So at the time of Runnymede, that wasn't as much a part of the equation. But it was Coke. Now Coke was there's four Stuart monarchs, right? There's James I, Charles I, Charles II, and James II. So Coke lived only under the first two. There was a revolution. They executed James I. There was the brief experiment under Cromwell, then the restoration of the monarchy, and then James II is also overthrown. So you have a century of civil war in England, over the rights, over the nature of rights and individual freedoms versus the government. That laid the foundation for the American Revolution. And they looked back at Magna Carta. One of my favorite Cook is, I love Lord Cook. As I said, he's the greatest lawyer in history. One of my favorite lines of Cook is, the Magna Carta is such a creature as has no master. And that was the attitude that led eventually, down the line to the American Revolution. And then, of course, to the Civil War, to the liberation of the slaves, and as the ultimate necessity to ratify the promise made in the Declaration of Independence.
Great. Okay. So basically, just to follow up real quickly, I won't go on to another. It's just that I have to ask this because, well, maybe I should ask you outside of this.
Yes, you should.
Okay.
John.
Yeah, he was right about the source being part, but we need to, we need to understand something, that the Founding Fathers were trying to create a new system, and they were looking at a system they were familiar with. Most of them were attorneys, so they were familiar with English law, they were familiar with the English Constitution and how it evolved. And they realized that something went amiss between even in the 1600s till 1776, in a 100-year period, a lot of constitutional rights were erased. So what they had to do was figure out, how is it that we peg this to something that is above the rule of man himself? So folk rights were erased, and I believe what they did was peg it to a higher source. Well, what's the higher source? Is God himself grants these. Because, natural laws and so forth was kind of a vague thing. Who's to define that? But if God grants us our rights, and I believe that's where they come from. But going back, yes, it's not a complete climb, straight climb. It's like the stock market. It's up and down, but when you measure it over time, you don't see those ups and downs. But the thing is when the Stuarts came, okay, and they tried to take away the rights, Charles I did. He tried to take the rights over in New England area, take away the charters and so forth. But he tried to do similar stuff too in England, and he lost his head. Okay, they cut it off. I was in Westminster, and I saw where he was sentenced. They cut off his head and returned it. But we also saw then his son, James II, came and tried to do the same thing. He didn't learn from his father's lesson, I guess, so he came and decided to try to do the same thing in the 1680s. And they ended up deposing him in the Glorious Revolution of 1688. And what is interesting is they ended up creating a document, the Declaration of Rights of 1689, which guaranteed the rights of Englishmen. And if you read the Declaration of Rights of 1689, it's in my book, they're there. You can compare it. I have the Constitution, I have the Bill of Rights in there. You can compare it. They're nearly identical. They're very similar. So what they did was, that was the rights of Englishmen. Because we need to remember, between the battles of Lexington and Concord and the Declaration of Independence, there was 14 months of warfare. Bunker Hill passed during that time. We got to ask ourselves, they haven't declared independence. So what were they fighting for? They say it in their petitions to the king. We are fighting for, you are violating our rights as freeborn Englishmen, over and over again. And in my book cover, you can see there, in that medallion there, on the cover there, that flag is the first flag of the United States. In the corner is the Union Jack of the time. That flag flew until 1777, when it was replaced by the Betsy Ross flag. But that flag was the flag that a young ensign by the name of John Paul Jones raised up on the first American warship, and it was the flag on which the Continental Congress debated the Declaration of Independence. It had a Union Jack in there. And one of the things that we need to remember is when they were debating on what was going to replace, a lot of people say, well, a lot of them resisted independence because they were afraid of the king or they were loyal to the king. No, they weren't. They were afraid of what was going to replace the king. Could you imagine? I mean, you're making a whole new country. What's the guarantee that what comes out of this is any better than what left? Or they also had fear, a realistic fear that they would be taken over by the French or the Spanish. As one person said, It was better to live under an English king, a British king with reduced rights, than to live under a French king with no rights. So this was a big fear for them. But at that time, when they were debating the Declaration of Independence, Jefferson stood up. And he said, isn't it time that we return ourselves to the form of government of our Saxon ancestors? The best form of government ever devised by the wit of man. Everybody understood what he said. And I wish I would have brought it, but when I go out and speak, I have a poster from high school history books from the 1880s. And it shows the Grand Union flag right next to the Stars and Stripes, showing in equal stature that it was equal and the predecessor to the Stars and Stripes. So there was a tradition, and the Founding Fathers understood it, but they also understood that the English system had flaws. And I mentioned that it had a living, what we would call today a living constitution that could be molded and moved around and adjusted. And they addressed that by having a written constitution that could be changed, but with some difficulty. It wasn't easy. They couldn't do it in the dead of night. There was a process there, because they knew even that wasn't perfect, the Constitution, and there might have to be some adjustments made. And this is why they took some of the principles and built it up from there. But as I say, and I think along Daniel Hannon's lines, what they did was take a car, strip the chassis, strip out everything they didn't like, and added what they wanted on it. And that created the American system, which is very unique. But you got to go back to de Tocqueville, who said the point of departure, he recognized this. In the 1830s, the point of departure for all these countries, and at the time, Australia really couldn't be considered, it was just kind of coming around. But there's a reason why the English-speaking nations of the world, Australia, New Zealand, Canada, the United States, Great Britain itself, all of them were free and prosperous nations. There had to be something in common there that ran through all of them. And it was the idea that the individual had rights.
There's a question down. We're running out of time. We won't be able to get to everybody's question. But
just a quick question. I want to hear what is your perspective that without a written constitution, judicial review would not be possible in the United States, since they don't have judicial review in England.
Did everybody hear the question?
No. I want to know what is your perspective on judicial review, that without a written constitution, judicial review would not be possible, since they don't have judicial review in England.
I agree with that. So judicial review is the idea that courts have the authority to strike down a law as unconstitutional. And the myth of this is that John Marshall invented this in Marbury versus Madison, and that's not true. The principle of judicial review is well known before then. And it comes in the Constitution, because the Constitution, at the end, it says, this Constitution and all laws made in pursuance thereof shall be the supreme law of the land. Which implies, of course, that laws not made in pursuance of the Constitution are not the supreme law of the land. So since a judge has to decide what is the law, he necessarily has to decide whether a purported law is made in pursuance of the Constitution or not. And if it's not, then it's not law, right? That's plain logic of judicial review. And in fact, you find it in the 17th century cases that used Magna Carta, right? When Lord Coke would strike down a monopoly as unconstitutional, for example, what he was doing was basically using Magna Carta as a kind of constitution, as saying the king can only act consistently with the law of the land. So now the king has acted. Is that consistent with the law of the land? And he would answer that question by consulting principles of reason. Another Cookism, the common law is like a deep well out of which every man draweth according to his understanding. He that reaches deepest sees the amiable and the admirable secrets of the law. So Cook says you can use reason to understand what is law. In fact, law itself is nothing but artificial reason, he says. Right? Now you can see this at work and this might appeal to the high school students too, you can see this at work in the modern age. Here's a case. You mentioned that great Fifth Circuit case. Here's a modern case that uses Magna Carta, lex terrae, law of the land style reasoning, and that's Gideon versus Wainwright, the famous 1960s case, which says that everyone has the right to a public defender when charged with a crime, right? If you can't afford an attorney, one will be provided for you by the state. The Supreme Court says that that's constitutionally required. When you read the opinion, they cite the Sixth Amendment guarantee of right of counsel, of course, the guarantee of right of counsel, but it only applies to a lawyer that you hire. What the court then goes on to say is that the 14th Amendment's due process clause, that is, the lex terrae clause of the Magna Carta that we currently have in the form of the 14th Amendment's due process clause, the due process clause requires that you be appointed a lawyer because trials are so complicated, the law is so complicated that even an educated layman couldn't possibly really defend himself from a serious criminal charge. It might as well be an arbitrary proceeding for a layman to try and defend himself from a crime. It might as well be flipping a coin. It's so unfair. And if it's unfair, then it's not law. And if it's not law, then it violates due process of law. That is amazing. That is 350-year-old common law reasoning, like Lord Coke would have said, written in 1963. So it shows you how this tradition of the law of the land, lex terrae tradition, has continued to the present day to protect individual rights against arbitrary government action. So yes, a written constitution is essential to judicial review. But remember, a lot of people will talk, they're critics of judicial review because they're opposed to the courts creating unenumerated rights, right? You often hear people say, oh, the courts shouldn't be creating rights that aren't written in the Constitution. Remember, the Magna Carta inaugurated a tradition whereby courts only protected unenumerated rights because there's no written British Constitution, right? So when an English court would uphold your rights under the lex terrae clause of Magna Carta in, say, 1600, 1700, whatever, it was enforcing unenumerated rights. This is the very core of the Anglo-American common law tradition, is independent courts protecting your rights as a sort of balance of power against the executive and legislative branches. I'm sorry to say that the modern legal tradition has largely turned away from that, so that both liberal and conservative judges today think that courts should not be in that job. They think courts should simply enforce the law, as if they are just ministers of the king, which is contrary to 800 years of Anglo-American common law tradition.
We have time for just one more question in this session. Linda Sachs, who's a descendant of the Saxons.
In the Magna Carta, it does, for example, make reference to two, in 11 and 12, I think it is at least, that to a non-free people, namely the Jews. And within 75 years of the Magna Carta being signed, the Jews were expelled completely from England for 400 years. My question is not so much about that as it is about my sense that the uniqueness of America's freedoms and American, the derivation from maybe the Magna Carta, et cetera, but the uniqueness in America was because within not just the Declaration of Independence, but within the Constitution is this biblical sense of the freedom of man and the value of individuals and the importance of judging people in an impartial way, and that this came from our founders' recognition of the essence of the Bible and of God, and that was unique in America because America, for hundreds of years, people were coming to America because of religious freedom.
Which biblical document?
Well, I'll let them talk. Yeah, I mean, I would say that the Talmud, but also just the 5 books of Moses, even that alone.
The Talmud is a commentary on the 5 books of Moses.
Right. Okay. Okay. That's all. So I'd like you to comment about the influence of religious freedom of the Bible on our founding documents, if you have an opinion.
Probably a question for John with the book on.
John, would you like to?
what the historians say.
Yeah. Excuse me, Dave, please. You're not answering this question.
It's true, because if we look at the English history when they came out of the Pilgrims, okay, they were what was called dissenters. They were not part of the Anglican Church, which was basically a state church. The Anglican Church was a church that was there to serve the state. And a lot of there was various sects. You had the Quakers, you had, up north, and you had the Calvinists up north in Scotland, and all these different sects, the Baptists coming out of England. And it's real interesting, the settlers around who came to, the colonists who came to America initially on the Mayflower, they all came from within 50 miles of one town in East Anglia. And what is interesting is that was the hotbed of the dissenters who resisted the Anglican Church. And what was interesting about these people, that theologically, that divided them from the Anglican Church, was that they took the Bible literally. They were what we would call evangelicals today. And there was no type of interpretation. There was nothing to, like the high church, the Anglican Church, would sometimes massage things in order for the state to do what the state wanted it to do. But they were strict Biblists, and that's where that tradition came from. It was brought over to New England, and then New England had always been a hotbed of the, up all the way through the Civil War, of this strict interpretation of the Bible, and taking the Bible very, very literally. And so these were worked in, as you mentioned. The Old Testament was worked in to a lot of the founding documents and the beliefs. And you end up seeing then, they expanded that by connecting our rights to God himself, and that they were granted. But this is the tradition, because, and of course, which has been completely distorted, maybe some of the attorneys can explain this, but of course the distortion now of the separation of church and state. You know, the idea was that, having dealt with the Anglican Church, the High Church of England, which was basically the church of the state, like I mentioned, they said, no, we can't have that. We're going to have it open. If you want to come and practice your religion, you can come and practice your religion. We aren't going to, the government's not going to endorse, nor is it going to obstruct the practice of a religion. And this is why they were very open. During the Constitution, there was a church, I think it's back in New Hampshire, but I might be wrong. It's actually a synagogue, one of the oldest synagogues in the United States. Which one is it? Rhode Island, okay. Right, and they went back, I think it was Jefferson and Washington, both went and spoke saying, look, because they were very concerned. What are our rights as Jews? What is our rights going to be? What's going to happen to us? And they said, no, under the Constitution, you will be able to practice. You will be welcome. And in fact, there were some references at the time, they called them Muhammad men. So there was even Muslims at the time, very, very, very small percentage, but there was Muslims, there's writing of Muhammad men within the colonies practicing their religion also. So it was always a very open, and there was avoidance to endorse one state religion.
If I just very briefly say, the Declaration straddles the secular and religious worlds quite nicely when it refers to nature and nature's God. And the reason for that is that although you can believe in natural rights from a religious perspective, it's not necessary to do so. You don't have to have a religious perspective. Or the way I like to put it is that you don't have to believe in God to know that man is not one. And all the Declaration says is man is not a God. And if man is not a God, he has no right to take rights away from other people. Now, John Adams, I'll read a brief paragraph for you from John Adams, in which he's talking about the formation of the American constitutions. He says, "It will never be pretended that any persons employed in that service had interviews with the gods or were in any degree under the inspiration of heaven, more than those who work upon ships or houses or laboring in the merchandise or agriculture industries. It will forever be acknowledged that these governments, were contrived merely by the use of reason and the senses. Neither the people nor their conventions, committees, or subcommittees considered legislation in any other light than as ordinary arts and sciences, only more important. So the founders saw their scope of writing a constitution as a purely secular enterprise that could be, but did not have to be, inspired by a religion. And therefore, they were open to religious liberty, not just toleration, which is what the British Constitution provided, but liberty. In fact, when writing the Virginia Declaration of Rights, George Mason, the elderly George Mason, was writing the Declaration of Rights, and this young 20-something intern interrupted him, of course, like they always do. His name was James Madison, and he said, Mr. Mason, you can't use the word toleration in there. You have to use the word liberty, and persuaded Mason to take out toleration and refer to religious liberty. And that is a perfect symbol of what I'm talking about, of the distinction between the British and the American systems. The British system in having toleration was wonderfully liberal compared to any other civilization before. And Blackstone is right when he says that subjects of the British Empire had more religious freedom than any other people ever did. That deserves praise, but it was still just toleration. And as Thomas Paine said, toleration is not the opposite of intoleration, but the counterfeit of it. Right? The government has no more right to give you religious freedom than it does to take it away. And that was the great innovation of the American Constitution.
We have to finish very quickly, but Byron wants to add something else.
Well, I was just going to second and maybe push a little further on that point. Not to deny that the religion was very influential for the founders, but the principles that they articulated, that are enunciated in these charters of freedom, as the National Archives calls them, they're universal principles that are not the claim of any one religion, any particular sect. They're principles of individual respect, individual dignity, choice, and autonomy that echo throughout the world. And although I've used the term, and I know the materials use the term Anglosphere for the heirs of the British tradition and the British Empire, these principles should not be seen as merely limited to that area as well. These are human principles of respect, dignity, autonomy, and they are found in many different religions as well as non-religious philosophers as well. And so I think it's an honor to see them really flowering in all of those different areas.
I'd like to end this panel. I wanted to say one thing before we do end. First of all, I want to say thank you to our excellent panelists. It was just terrific to hear such an erudite presentation. I want to say one thing, and that's the survival of the manuscripts of Magna Carta. It is an extraordinary thing in itself, because England passed through countless civil wars, despoliation of churches, which is usually where the Magna Carta was held and preserved. It was ransacked, you know, it went through a major civil war in the 1640s, and tyrannies, and the extraordinary thing is the Magna Carta documents survived. How did they survive? They survived because there were people who saw these as sacred documents and hid them from, and that's such an interesting thing for me to think, to conjecture, you know, why people did it. And it could only because this was a document that had to be preserved, because this preserved freedom and liberty. With that, thank you very much. We're going to take a break for 15 minutes. We'll be back with the second panel.